Subco wanted to license some technology that Subco owns to a company that is wholly owned subsidiary of Disco Berhad. Rufus, who is the minority shareholder in Subco, was not happy with the decision. This is because the decision was made despite the existence of better offers from several other third parties. He believed that this is a breach of directors' duties. The issue that arises from the case is that, first, can he apply to court under Section 181A Companies Act 1965 to bring a statutory derivative action in respect of the alleged breach? Explain the requirement for that leave to be granted. Secondly, is he also allowed to bring a derivative action under the common law? If yes, what are the factors that will influence the court to make the order? Finally, Rufus' lawyer says that as an alternative, he may apply to have the company wound up. Do you think the court is likely to make a winding up order? To answer the first issue, we first need to know what is derivative action. A derivative action is an action brought by a shareholder based on a cause of action that the company has, rather than a cause of action belonging to the shareholder. The common law allows a minority shareholder to bring this action on behalf of the company in situation where the company does not take action because the wrongdoer controls the company and is able to prevent the company from taking any action. The new statutory derivative action under Section 181A to 181E of the Companies Act 1965 allows a complainant to apply for leave of the court to bring an action on behalf of the company. This new action, which came into effect on 15 August 2007 under the Companies Amendment Act 2007, allows a shareholder to sidestep the restriction of the common law derivative action. Moving on to the second part of the first issue, there are basically three requirements for leave to be granted by court, which are first, notice, second, good faith, third, prima facie in the best interest of company. The first requirement in applying for leave of the court is that the complainant must give 30 days notice in writing to the directors of his intention to apply for leave under Section 181A of the Act. The purpose of this compulsory notice is to first give the company the opportunity, through its board of directors, to consider its right and course of action. After the 30-day notice, a complainant can make an application by originating summons for leave of the court as required by Section 181B of the Act. There are two requirements which the court shall take into account when deciding whether or not to grant leave. The first is whether the complainant is acting in good faith. The second requirement which must be demonstrated is that it appears prima facie to be in the best interest of the company that the application for leave be granted, as observed in Agus Irawan. This requirement of good faith overlaps with the requirement that the claim must be in the interest of the company. The court may also weigh the availability of an alternative remedy such as the winding up of the company. In Pang Yang Hock, where there was an impasse in the management of the company and the company was not performing well financially, the appropriate solution in that case was to wind up the company.
For the second issue, on the whether or not he is allowed to bring a derivative action under common law, the ruling in the case of Force against Harbottle states that if a company suffers a wrong, then because of it is a separate legal entity from its shareholders, prima facie is the company that should bring an action. Such a rule allowed a shareholder to bring an action on behalf of the company if two elements could be proved. The first element is that the wrong is one that cannot be validly ratified by the majority as there has been a fraud in the minority. And the second element is that the proprietor of the fraud were in control of the company, hence Rufus is able to bring a derivative action under common law if he could prove both the elements mentioned above. For the second limb of the second issue, if it is true that there are factors that will influence the court to make the decision by referring to the case of Edwards against Aldiwell, some of the factors include ultra-virus acts, where in the cases of the act complained are wholly ultra-virus to the company. The rule has no application because there is no question of the transaction being confirmed by any majority. Other factors included fraud on the minority, where the wrongdoers are themselves in control of the company, a special majority, personal rights, where the personal and individual rights of the members have been invaded, and lastly, when the justice of the case requires it.
The third issue is whether the court is likely to make a winding up order in favor of Rufus. Section 181 provides for the remedies in cases of oppression where the court may make order for the company to be wound up if it can establish that there exists a disregard of members' interests or unfair discrimination against members. In the case of Brie Kong Tai Sawmill, in order to apply for relief under this section, the complainant must identify and prove the element of oppression or disregard. In order to prove the element of oppression, the question to be answered is whether there is a visible departure from the standards of the fair dealing and a violation of the conditions of fair play, which a shareholder is entitled to expect before a case of oppression can be made out. In this case, there is no significant departure from the standards of fair dealings. Even though there are other better offers, the decision made by the board of Subco does not constitute a violation of the conditions of fair play. Hence, the element of oppression cannot be established. The second element is that whether there has been a disregard of the minority's interest. In this case, it could not be proven that the board of Subco is aware of Rufus' interest. The board's decision to choose a company not agreed by Rufus does not mean that it purposely intended to set aside the minority's interest. Hence, the element of disregard cannot be established. In conclusion, the court is not likely to make order for winding up the company because the elements of oppression is not fulfilled. Even though the grant of winding up was at the discretion of the court must also bear in mind the effects of the remedy if it sought to apply to a company. It will take into account, first, the gravity of the case under Section 181 subsection 1. Second, the possibility of remedy other ways than by winding up the company. Third, the interest of the applicant in the company, and lastly, the interest of other members of the company not involved in the proceedings. Even when either of the oppression or the disregard element can be proved, it is not likely for the court to resort to wind up the company. In Rufus' situation, the court may not order for the winding up of the company if the court finds other remedies to be more fitting.